Hi, so attorney Lacey Thompson here. A lot of the things that we post on our page talks about criminal defense, but sometimes we'll get civil related questions like, can I file a lawsuit against the police for arresting me since I didn't do it? It's not something we often see. We don't get that question like every single phone call, but I do think it's regularly enough to talk about. So, if your case is dismissed, can you sue the police? If while it's pending, can you sue the police if you didn't do it? What that boils down to is probable cause. So the police have to have probable cause in order to make an arrest. That has to be more than a hunch, but it's less than what it takes to convict somebody. Proof beyond reasonable doubt is what it takes to convict somebody. That's the standard. So that probable cause, it might be based on, if you're pulled over for DUI, that's going to be based on your field sobriety test. If you smell like alcohol, you're unsteady on your feet, how you're driving, all those little pieces can add up to probable cause to make that arrest. If you go in and give a breath sample of a 0, well, hey, I wasn't drinking and driving. But if you then refuse the blood or urinalysis, well, that could mean that there's something else impairing you. And so there's still going to be enough probable cause if there's issues with field sobriety tests, or they, saw that you were driving and there were pills in your car. But that's what they're looking at as far as, probable cause in a case. That could mean a witness statement. It could mean somebody stating that you committed a crime. That can too sometimes add up to enough probable cause. If there's no probable cause, only then could someone sue law enforcement for wrongful arrest. It's called a 1983 action. So that's very rare because probable cause is such a low burden, but I have seen it. I have seen cases where I've told my clients, I don't think there was any evidence to arrest you, and you could seek to sue the police. But like I said, it's extremely, extremely rare. In one of those cases, my client was the one that actually called the police. There was clear physical evidence of a crime being committed against my client when he was the one put in handcuffs. I don't think the family ever did, but I did think he had grounds for a civil lawsuit. So we don't do civil lawsuits. We don't handle 1983 actions. If we think that it's a case that the police got it gravely wrong and there was such an injustice, we can point our clients to referrals. But I will also say that those attorneys, also the criminal case has to be dismissed in order for you to have a claim. So you still would need a criminal defense attorney fighting the charge, even if we do think there's no evidence. And at the beginning, it's really hard to tell, right? Somebody says their story and tells us what happens, but we actually have to see the body cams, the dash cams, and there actually may be evidence when our client feels that there's not. One thing I've learned in this job is it's hard for our people calling not familiar with the law to accept that testimony is evidence, right? A witness making a claim is evidence. Whether it's credible or not, whether it's credible evidence or not, that's going to be seen later on. But it is still evidence. It is evidence that the police can rely on, and it is oftentimes enough evidence to validate probable cause, which is going to bar somebody from any type of lawsuit against the police. So, like I said, we often get, not too often, like I said, but it is a regular question that we get asked is, can you sue the police? And in certain situations, you can. It's very rare. And if your case is one of those cases where it is very egregious, we will fight vigorously for you. And if we get your case dismissed, we'll let you know some great referrals if it needs to go further than that. So if you've got a case, if you wish to talk about it, give us a call at our Myrtle Beach office or our Columbia office, numbers below. Thanks.